So that was the Senate Judiciary Committee hearing today on the strange ethics world of the United States Supreme Court. What were the most important highlights of today's hearing?
Well, I think they actually make a really good contrast with the discussion we were just having about Special Counsel Smith potentially asking Judge Cannon to recuse. If he decides to do that, that battle will be fought on a landscape of facts. He'll be making factual allegations. There'll be factual evidence. There'll be assertions of fact about what her liabilities are in terms of her ability to be fair. Switch to the Supreme Court and look at, for instance, the example we were talking about then, Justice Thomas failing to recuse from the January 6 investigations. Whether or not his failure to recuse was lawful entirely depends on a fact. And that fact is what he knew about his wife's conduct regarding the insurrection. And he's never been obliged to answer that question. There's no record of fact. And you can look at other areas. You've got groups like Americans for Prosperity and Judicial Crisis Network that spent millions of dollars getting these judges on the Supreme Court, and their affiliate corporations appear writing briefs in the court without disclosing that link. Again, if that expenditure of millions of dollars to get justices on the court could give rise to recusal, you need to know the facts. And I think what's important here is that the Supreme Court exists not just in an ethics-free zone as to recusals, but in a fact-free zone where they will never disclose what really is going on.
On another point, Chairman Durbin, in a question to Donald Sherman, who's an ethics expert, Sherman actually says there is a violation of law on this. Let's listen to this.
Justice Thomas, when he did not disclose at the Supreme Court level, was he in violation of any law that you think applies?
The payment of his actual travel to the location on the private jet, his travel on the boats, especially because that travel, as we understand it, was funded by a private company and not actually the hospitality of Mr. Crow, needed to be disclosed and was a violation of federal law.
And Senator, what's the remedy for that?
Well, the Judicial Conference is supposed to look at that. Mr. Sherman is exactly correct. The excuse for not reporting is that it's personal hospitality. Personal hospitality only covers food, lodging, and entertainment. It does not cover travel. So the jet and yacht travel, certainly the jet travel, if you want to argue that yachts are hospitality, but for sure, no doubt, the jet travel should have been reported. There's no excuse for that. And once again, we don't get to find those facts. There's no accountability. There's no process. And that's a very significant problem for the court.
And what happens to Justice Thomas if he doesn't respond in any way, when you have experts saying that's a violation of federal law, and he doesn't respond in any way?
Well, here's what's supposed to happen. And it happened once about a decade ago, and it wasn't done very well then by the Judicial Conference. So we hope they'll do a better job this time. But the question of his failure to file gets referred to the Financial Disclosure Committee of the Judicial Conference. And if there's a question about whether it was willful, the failure to file, then that question of whether it was willful should be referred to the Attorney General, to Attorney General Garland, to do an investigation of willfulness and make the finding of whether or not the failure to file was willful. So one important test of the Judicial Conference in giving a more transparent and correct look at the situation in this episode of Harlan Crow to Thomas yacht and jet gifts is whether or not they make that referral to the Attorney General to make a determination of willfulness in failing to disclose jet travel.
But then what would the Attorney General's options be if he found it to be willful?
So there are civil penalties available under the statute, and he could pursue civil penalties. But if you take a look at the criminal code, 18 United States Code, Section 1001, the famous false statements law, that actually provides criminal penalties for filing a false statement. So if the Attorney General thought that the statement was so false and the conduct was so willful that it merited being treated as a criminal act, then that would be available as well.
I think what the audience is hearing in the realistic view of that is that that will simply never happen, that it doesn't matter how unlawful that was. In our current politics, in our current government, with the sensitivities that exist, this Attorney General would never prosecute a Supreme Court justice for that.
But he'd have the civil remedies available, and he could pursue the civil remedies also. So he has an array of potential sanctions that he could bring to bear on this conduct.
Senator Sheldon Whitehouse, thank you very much for joining us tonight. By the way, you did do a podcast. You are doing a podcast of your, what has been your lonely crusade on explaining how the Federalist Society has taken over the Republican side of the judiciary. The podcast is Making the Case, right?
I'll blame you, because early on you talked about one of my scheme speeches and said, you know, that would make a pretty good podcast.
Yeah,
we've done it.
And it is a great podcast. Senator, thank you very much for joining us tonight.
Thank you, sir.
Thank you.